Hi, I am Tom Daly. I'm a partner at Roca Rothgerber Christie, and I practice in the Intellectual Property Practice Group.
And I'm Drew Wilson. I'm an attorney at Roca Rothgerber Christie, and I also practice in the Intellectual Property Group.
And today we're going to be talking about various different ways that you can protect the outward appearance of a product.
There's a number of products that work really well with design patents. Usually you want to get a design patent for a product that's going to have a short lifespan, something that you change the configuration of regularly. So shoes are a great example of a product that every 5-10 years there's a new shoe model that comes out. Same thing with cell phones. Think about the evolution of cell phones over the last 10 years. How we've gone from the old flip phone to the giant phablets now. Also, any product where there might be a small component of it that really sticks out, and that's the thing that people focus on, that can be useful for a design patent because you might not be able to protect that particular feature of the product with other forms of intellectual property. There are a number of advantages of a design patent over other forms of intellectual property. One of the advantages of a design patent over, say, a trade dress rights is that a design patent doesn't require proof of secondary meaning. It's much, much easier to obtain. You don't have to show that customers associate the product that you're protecting with a design patent with a single company. You can, in fact, if you're smart, use a design patent to get a period of exclusivity that you can then use in order to obtain trade dress rights, which then have potentially infinite duration. Another advantage of a design patent over other forms of intellectual property rights is that you can get a design patent on much smaller features of the product configuration. I've actually had a client who makes aftermarket wheels, and we've been able to obtain a design patent on a little tiny pill-shaped divot that was about yay big that was around the outside of the border of the wheel. You wouldn't be able to get that with copyright, which requires that you can perceive the artistic work independently of the product, or with trade dress rights. So that's really...
Trade dress would look at the product as a whole.
Exactly.
So another advantage of design patents is when you are enforcing design patent rights, the damages can be much better. So when you're looking at design patents as a way to protect product configuration, one of the things you have to think about is that it's time sensitive. So a disadvantage is that you have to move very quickly. You have to be prepared to pursue that design patent protection either before you introduce the product to the public or very soon after you introduce it. You also have a kind of a high hurdle to meet in the sense that you have to show that your design is both new and unobvious. So just a minor change in design is not something that you're going to be able to protect with a design patent. The other thing, too, is although 15 years seems like a long time, in the lifetime of a product, something like the Coke bottle, which has been around for over 100 years, 15 years is only a short term of protection. So one of the downsides to design patents is the fact that you're just going to get that 15-year time frame. The other issue that you run into is with trademark registrations, with copyright registrations. You can register those with customs, and you can then use customs to help block the infringing products that are being imported at the border. With design patents, that's not possible. You can't just register them with customs. You have to go through the US ITC, which is a much more difficult process. There are some proposals to change the law to make design patents registrable with customs, but that hasn't been enacted into law yet. So with design patents, time is of the essence. You want to file the design patent preferably before the product is introduced, because if you want to protect that design in foreign countries, there are a number of other countries where you have what are called absolute novelty requirements. So once a product is introduced to the public, you can no longer protect it with a patent, design patent in those countries. In the US, they give you a grace period, so you have a little bit of time after you introduce the product. So worst case, if you don't get the design patent application on file before you introduce the product to the public, you want to do it very quickly after you've done that so that you can at least protect the design in the United States. So when you're looking at design patent as a way to protect product configuration, you have to keep in mind that it may not even apply to certain products. Your product design is going to have to be new and unobvious. So you're going to have to make sure that design patent even applies. The other problem with the design patents is that they have a limited lifetime. They are only going to last 15 years from when you first obtain your patent. And so if you think that your product is going to have it's going to be a classic, it's going to be around forever, like the Coke bottle, which was covered by design patent and now is protected by a trade dress trademark registration. So you only have a limited lifetime with design patents. That's a downside. Also, you have the fact that they're time sensitive. So if you don't apply for your design patent within 1 year of introducing your product, you're no longer going to have that opportunity to get that protection.